Hi everyone, I'm Sabrina.
And I'm Jonathan.
And we're the lawyers at Verity Law. Today we will talk about inheritance and estate planning.
Well, most people do not think about inheritance or estate planning, and the assumption is that surely there's a government process to take care of the whole thing.
Actually, it's not that simple. So John, let's take the example of Charlie, who wants to pass everything to his daughter Claire.
After Charlie passes, the majority of his assets would be frozen. Claire cannot get the estate until she files a probate application and receives court approval. But there are a few types of assets that can automatically pass to Claire. She only has to provide Charlie's death certificate. So how about Charlie just set up everything as an automatic transfer?
Well, you can't actually do that because in reality, only very few types of assets can be set up as automatic transfer. So for example, anything that Charlie jointly owns with Claire can be passed down automatically with just a death certificate, including his joint bank account and any real estate held as joint tenants, meaning that the two words joint tenants is written on Charlie's deed.
But there is a problem with setting everything as jointly owned with Claire, because the moment that Charlie adds Claire as a joint owner, she can take out all of the money from the joint account without Charlie's permission. Also, for the jointly owned real estate property, now Charlie must get Claire's written agreement anytime he wants to mortgage, rent, or sell the property. So joint accounts are not suitable for every family. What can Charlie do then?
Well, alternatively, he can set up his assets with designated beneficiaries. So his TFSA and RSP at the bank, he can do that. At the time that he gets the TFSA and RSP, he can select Claire as the designated beneficiary. Then Claire would get those funds easily and immediately right after Charlie passes. And she will have no access nor control of those funds before Charlie passes, unlike in the case of joint accounts.
But do be careful here. Charlie must state that the beneficiary is Claire Johnson instead of just vaguely saying, my children, for example. Wouldn't it be great if all your assets could be set up this way?
Yeah, of course. But unfortunately, you cannot do that. Most of your checking, saving, and investment bank accounts do not have the option of setting a designated beneficiary. So now, what if Charlie has business assets that he wants to pass down?
Then he's in luck. If he creates two sets of legal documents, then his business assets can automatically be transferred to Claire. First, he needs a corporate minute book that shows he's the owner of the company. This is different from your registered articles, which only shows who manages the company. If Charlie doesn't have a corporate minute book, then he needs to get one done right away by a law firm.
How come the minute book isn't registered with the government when Charlie incorporated his company?
That's a good question. Now, because the government wants to protect shareholder privacy and does not want anyone to just look up who the shareholders are, this information isn't available. Also, often shareholders get updated frequently, so registering each time would be very time-consuming. What is the second document that Charlie needs?
So, in addition to the corporate minute book, he needs a secondary or corporate will. This is different from Charlie's personal will because it specifically lists assets that would not require probate to be passed down. So usually Charlie's business assets. The good news is anything that is passed down through the corporate will, Claire gets automatically, only with a death certificate. She doesn't need to file for probate, and she doesn't need to pay the 1.5% estate taxes, which is applicable for any estate that is above $50,000. Is there any other way for Charlie to automatically pass down his assets?
Lastly, anything passed down through a trust is automatically inherited by Claire. In general, trusts are a legal structure created by a set of legal documents that distribute assets to the preset beneficiaries. One of the major benefits of trusts is that assets in the trust can be distributed gradually, year by year, instead of all at once within the year that Charlie dies. Trusts also have many other benefits, including tax planning and asset protection. Now, trusts are a very complex topic, and we will explore them further in our next video.
All right, sounds good. And there you have it. Those are the only assets that can be passed down automatically. So every other type of assets will be frozen when Charlie passes. And Claire must get a court approval document before she can receive her inheritance. Now, how do you get this court approval? So Claire's or her estate lawyer must file this thing called a probate application to the court. There are three types of applications: small estate, probate with a will, and probate without a will. Now, small estates applies when the total estate asset is under $150,000. You should provide proof of this, such as the deceased bank accounts and car valuation. But for most families, their estate asset will be higher than $150,000, right? So in those cases, having a valid will makes a world of difference. If there's no will, then Charlie's assets must be distributed according to estate law, which means that Charlie's wife will get a fixed amount of money called the preferential share. So right now that's $350,000. So that's the first amount from the estate that his wife would get. And then after the $350,000, Charlie's wife would get one half of the leftover and Claire will get the other half. In contrast, if Charlie actually had a will, then he can actually specifically say that everything goes to his daughter Claire or anyone else. His inheritance would not be strictly divided according to legislation. So is the process of probate without a will also harder than if you have a will?
Oh, definitely. The legal fees for filing a probate with a will is much lower than probate without a will. The time it takes for the court to review the file with the will is also much faster, usually 1 to 2 months compared to 6 months or more when there is no will. Now, very importantly, all of Charlie's debt, including his mortgage, car lease, and even credit cards, becomes due entirely and immediately upon his passing. This means that Claire cannot even continue to the monthly mortgage payments. She must figure out a way to pay off the mortgage entirely by either selling the house or applying for a new mortgage herself. But how would Claire pay for the estate debts if she cannot use the estate funds until the court approves the probate application?
Yeah, that's the chicken or egg problem, right? So Claire needs Charlie's estate money to pay off the mortgage, but she cannot get Charlie's estate money until the court gives approval for the probate application. So what to do? To solve this problem, Charlie should have left Claire an automatic transfer asset such as life insurance. So after Charlie passes, Claire can get the life insurance really fast, for example, within 5 days. Then with that life insurance money, she can then pay off the mortgage. And Charlie should left the will, because with a will, Claire can get the court approval usually within 1 to 2 months, but without a will, it's usually 6 months or more that his assets will be frozen. So John, other than the estate debt, is there anything that Charlie needs to worry about?
Actually, yes. Claire also needs to think about the probate taxes. When she files her probate application, a 1.5% tax for all assets over $50,000 is applicable. So if Charlie's estate is worth $1 million, then the probate taxes payable would be $14,250. While the court prefers that Claire pay this out of her own pocket at the time she files the probate application, our firm will ask the court to delay that payment of probate taxes for 6 months until after the probate approval is given, so Claire can then use the estate funds to pay that tax. But what about Charlie's income tax?
Yeah, that's right. So even though Charlie have passed, his last year of income tax, which is when he passes, still has to be filed. So if he passed away in 2021, then his 2021 taxes must be paid. So Claire has to figure out a way to pay for her father's income taxes. She can hire the same accountant that her father always used to do this. Now here is where estate planning really shines. If her father, Charlie, did not do any estate planning, then CRA will assume that all the inheritance he left to Claire, he sold to her at fair market value and he earned this much money. So when he filed for his last year of taxes, he must pay income taxes on all of the things he sold to Claire.
Another problem arises. Without a will or a list of assets, Claire does not even know what her father owned or what his debts were. It may take her months or even years to find out the details for his estate. While some things can be looked up, like a real estate lawyer can look up real estate ownership, other things are kept private, such as how much money Charlie has in his bank and what banks he uses. She and her probate lawyers would need to work together to correspond with all possible institutions where her father may have had assets, but this process is very long and expensive.
That is why at our firm, in addition to doing the will, we help the client start a list of assets and debt, which they can keep completely confidential and private, and they can update themselves. So Charlie could specifically write down the addresses of his real estate properties, for example, and here are my bank account number, and you'll be kept confidential and only given to Claire when it's time. That way, when he passes, Claire knows exactly what her father has, and it will save so much pain involved in finding out his assets.
Charlie can also update this list at any time. He doesn't need to update the will just because the assets change.
Okay, so in summary, for Charlie to ensure his daughter Claire gets his estate, he should set up some assets as automatic transfer, such as life insurance, and things like TFSA or RSP, with Claire as the designated beneficiary.
Okay, and then he should have a valid will with an experienced estate lawyer too, and keep that in a detailed and up-to-date asset list. If he has corporate assets, he should also write a corporate will.
Lastly, if he wants Claire to receive the assets year by year instead of all at once, he should consider doing a trust.
Well, that is all for today. Stay tuned for our future videos regarding what makes a will valid and enforceable.
Thank you for watching.